What are safety protection plans, and do I have to agree to one?
In New Jersey, DCPP is required to initiate a safety and protection plan anytime that they believe that a child is at risk of harm in your care. That doesn't mean that they have found that you have committed child abuse and neglect. In fact, safety and protection plans are often proposed early on in an investigation because they don't yet know whether or not you did what you're accused of doing. So they want to make sure that they maintain the status quo and that your child, if your child is at risk or if your child has been harmed, is no longer harmed and is no longer placed at risk while they are investigating whether or not something happened. So typically, safety and protection plans are going to address issues such as whether or not one parent has to move out of the home during the investigation, or whether or not a child has to be supervised in the care of a parent during the investigation. These specific restrictions upon your access are typically requested for you to consent to so that the agency does not have to go to court. But it's very important that you consult with a DCPP attorney because sometimes agreeing to a safety and protection plan can be used against you. If you agree to restrictions that are put in place that are onerous, that give you limited access to your child, and then later the agency makes a finding and goes to court, the agency is going to rely upon the fact that a safety and protection plan was in place that gave you limited access, and they're going to want to maintain that. So it's very important that you negotiate your safety and protection plan with the assistance of a DCPP attorney before you agree to one.